Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the incredible Chad Michaelson, a Pennsylvania construction lien law guru. Today's webinar topic is getting paid faster with liens, bonds, and contracts. So without further ado, I would like to introduce the fabulous Chad Michaelson.
Well, thank you for the introduction. As Jesse said, we're doing a webinar today, and if you have questions during the webinar, you can put them in the chat on the right-hand side, and I'll try to address those either as we're going through this or at the end. And as the note says, don't include anything specific in the questions, but feel free to ask. So the topic today is getting paid, strategies for getting paid, and there are three things we're going to talk about. The first of that is using your contract. Oftentimes it might not be your contract. If it is, that's great. There's a lot more you can do with it. If it's somebody else's contract, though, there are a few things that are worthwhile to negotiate. First thing you want to look at when somebody hands you a subcontract or a contract is obviously the time for payment. I see a lot of those lately that are 45 days and more, which shouldn't. You should push back, obviously, to try to shorten that as much as you can, because look, even if the contract says 20 days, that might not happen. So the shorter time in the contract, the better. In Pennsylvania, our Contractor and Subcontractor Payment Act says that if the contract is silent on the time for payment, then the subcontractor has to be paid within 14 days after the owner pays the general for that work. That's only if the contract is silent. If your contract says that the general doesn't have to pay a subcontractor for 30 days, then that governs. But if there's nothing in the contract about timing, it's 14 days. The other thing that we tell people to look at is the pay when paid, pay if paid clause versus a pay when paid clause. So even CASPA, I just said, recognizes that there's a pay when paid component, that the subcontractor should get paid promptly after the owner pays. So most contracts, are going to be triggered by the owner payment. A lot of those general contractor subcontracts will say you only get paid if we get paid. And if you change that to a pay when paid, you have a better chance of getting paid if the general has some problems with the owner. The pay if paid is absolute. It's if the owner doesn't pay, you don't get paid. Pay when paid is a little bit different. It says you're entitled to your money. It's just a matter of when you get it. Your contract should include interest on late payments. The CASPA interest is 1% per month. But again, that says unless your contract says something to the contrary. So if your contract says 6% a year, then it's 0.5% per month. But I've seen a lot of contracts that folks write in no interest, and the no interest would trump CASPA. So if the owner or the general contractor pays you late, you get nothing, and that's not right either. So think about the interest in the contract as an incentive to timely payment. Look at what the contract says about your right to suspend work for non-payment. CASPA was amended a couple of years ago to include a provision allowing contractors to suspend work for non-payment. It requires that the owner be behind, and then there's another notice and a waiting period. And so it's sort of a longish period. It's probably 45 days at least until you can actually suspend work under CASPA, but you can have different provisions in the contract. Standard contracts say that you will continue working while there are any disputes about change orders and things like that. You won't not work if that's ongoing, but that doesn't apply to non-payment. You should really talk about upfront about what happens if you're not paid, and explain that if that goes on for too long, you're going to stop your work, and make sure you're allowed to do that under the contract. If you have the opportunity, you should include a provision in your subcontract that allows you to get attorney's fees if you have to file suit to collect payment. That will be enforced in Pennsylvania, and will allow you to be made whole. Obviously, if somebody doesn't pay and you have to sue them, the lawyer's fees eat into your profits there. So including attorney's fees in your contract is a smart idea. And finally, that last bullet is really just don't give them excuses to withhold money or delay payment. That means think about your payment applications, look carefully at what the requirements are in the contract that you have to submit with your payment applications. Make sure you submit your proper waivers. That's the biggest reason I see for withholding, is that contractors or subs can't supply lien waivers from lower tier contractors, and so the owner, is withholding money to protect themselves from liens. So make sure you get your lien waivers in order. Provide all the supporting documentation, whether that's certified payrolls or some kind of, MBE or DBE report. Don't give them excuses to delay paying you. So those are a few of the things you can think about in your contract. The other strategies that we laid out at the outset here were bonds and liens. And so I want to talk about payment bonds for a second. Those are prevalent on jobs. I see some jobs without payment bonds, but the vast majority have a payment bond. Either it's government project, which requires a payment bond in Pennsylvania, or it's private. And the importance of payment bonds is twofold, because it's also related to your lien rights. So the first question you ask yourself when you are signing the contract is this project bonded? I mean, you need to know that to understand what your recourse is going to be if there is a payment problem. And if the project is bonded, you need to get a copy. Now, I'm going to talk about that a little bit when it comes to liens, because if somebody's asking you to waive your lien rights, there has to be a bond out there, and that gives you a good excuse to ask for it. But get the bond up front. Contractors, subcontractors often have trouble because when they're not paid and they want to make a bond claim, they can't get their hands on a copy of the bond. And if you can't get your hands on a copy of the bond, then you can't comply with its conditions, right? Bonds typically have notice requirements. They have a deadline by which you have to file claims. You might have to file a claim within a year after the project is completed, or within a year after you're not paid for the materials you've supplied after you finished your work. So make sure that you have a copy of the bond. That's one of the best defenses a surety could raise, or that a contractor could raise. If a bond says that you have to provide notice to the surety and the owner, or to the surety and the principal on the bond, and you don't do it, then your claim might go away and you might lose that important security. So don't wait until the end of the project to try to get a bond, a copy of the bond. The third point here says be prepared to prove the labor and materials were supplied to the project. That sounds like it would be easy, but oftentimes that's a matter of contention in payment bond claims. So it's not enough necessarily to have, it helps, but it's not enough to have delivery tickets saying materials were supplied to the project, for instance. You need to be able to prove that they were actually incorporated into the work. So daily reports or other records like that to prove that either the labor was supplied to the project or that the materials that haven't been paid for have been supplied to the project. So keep that in mind. That's going to be your burden if you make a payment bond claim, and you might get in an argument about that with the surety or the principal on the bond. So again, read the bond carefully to make sure you can comply, and make sure that you file suit within the timeframes on the bond. But again, all of that is contingent on the idea that you need to get a copy of the bond. Now, bonds and lien rights are closely related in Pennsylvania, at least payment bonds are. In Pennsylvania, it is illegal and it is not possible for a subcontractor or a general contractor to waive their lien rights in advance before they're paid. The law says that the only waivers that are effective are waivers that are for payment received. So when you get paid on that first payment application and you submit with your second payment application a waiver that says I waive my rights for the money the payment I received on the prior, that's effective. But you can't at the beginning of a job sign a contract that says you waive your lien rights. So if your contract says that, you should either negotiate it out because it's illegal or not worry about it because it can't be enforced. Right? However, there's one important exception to that rule, and that's this. If a payment bond is present, if the general contractor has posted a payment bond, then the owner or the general contractor can file a notice and record a notice with the recorder of deeds in the county where the project is located, a no lien agreement, a notice of a payment bond, and a no lien agreement. And in your contract then, it will say that you waive your lien rights and that this notice has been supplied. So that has to be in the subcontract, but the general contractor can waive all subcontractor and supplier lien rights by posting a payment bond. What that means is that you do in fact lose your right to file a lien on the project, even though you didn't personally agree to it, but you have a bond to backstop you. And so this is another time when you look at a contract initially and it says, I waive my lien rights, then it's perfectly legitimate to say, I want to see a copy of the payment bond, because without the payment bond, that waiver is not effective. So it's a good excuse up front to get yourself a copy of the bond. Now, with respect to using liens to get paid, let me reverse these next two bullet points. So the third bullet point is threaten your liens early and do not wait until the last day. Sometimes the threat of a lien is enough to get paid. And so you don't want to, the instinct is always not to be difficult, to try to be a good partner, not to threaten liens, just to ask for payment. But that usually doesn't work or ends up biting you because you try to work with the owner until you get to the point where you're almost out of time to file a lien. In Pennsylvania, a subcontractor only has 5 months from the date of its last work to serve notice that it intends to file a lien. Only 5 months. And a general contractor has 6 months. And the reason is that subcontractors and suppliers, anybody who doesn't have a contract with the owner, has to provide notice of intent to file a lien at least 30 days before they do it. So a general doesn't have to file the notice of intent to lien. A general has 6 months from the date of their last work to just file the lien. But everybody else only has 5 months because you have to give this notice within 30 days. And the time is strictly enforced, and sometimes it's difficult to give this notice. So if you wait until the last day of the 5th month, you can really put yourself in a bad position. So threaten liens early. Be prepared to file the liens early. It's actually worth it to get an attorney or contact SunRay to prepare your lien documents, even if you're still negotiating with the owner, so that you have them ready to go. The other thing that will help you enforce your lien rights is to actually spend the time up front to find out who owns the property. That is often not the owner on the contract. Your mechanic's lien is filed against the property and against its owner. And so oftentimes clients will contact me and say they want to file a lien, and I'll look at the contract, and then I'll look at public records and I'll see that the name of the owner of the parcel is different. Sometimes I can't even identify the parcel. So we have to spend a lot of time figuring out what is, who is the legal owner of this parcel where you're doing this construction, track them down and figure out how to serve them. So that takes time. And again, if you call me at the end of 5 months, or you're asking SunRay to put this together, then we don't have the ability to do all that work that's necessary. In Pennsylvania, the lien document is in a prescribed form. There's a lot of information that has to be in it. If any of that is missing or wrong, your lien could be invalidated. they're very strict about compliance with the rules, and liens are often invalidated for very technical reasons. So it's important to do your homework. And just as it's important to get a copy of a payment bond up front, it's important to find out who owns the property, because that's one of the hardest things sometimes when we have to start preparing lien, is figure out who's the lien being filed against and what parcels is it being filed against. So then, of course, I guess I've already hinted at this, but liens are tricky, especially in Pennsylvania, because we have 8 or 9 different requirements that have to be in your lien filing. And sometimes they get complicated. So you need to contact someone who understands that, like SunRay, or a lawyer in Pennsylvania who can help you make sure that you have a valid lien to protect your rights. Now, once the lien is filed, sometimes that is enough to get you paid, because the lien will cause problems for the owner's construction financing, or perhaps other consequences that they want to avoid. So sometimes that gains enough leverage to get paid. Sometimes it doesn't. The lien itself doesn't get you any money. It's just a lien on the property. In order to actually collect money, you need to file a lawsuit to collect on the lien, a lawsuit to enforce the lien. That proceeds pretty much as an ordinary lawsuit, but it's limited to what you can collect on the lien, which is the value of the labor and materials you supply. What you can't claim in that lawsuit are other things that aren't within the lien law. And the most notable example of that are CASPA damages. CASPA is a separate statute. And so if you have a breach of contract claim because somebody hasn't paid you, you can file a lien and file a lawsuit to collect on the lien. But oftentimes, we'll file a separate lawsuit that claims a breach of contract, and then claims those other damages, like interest or attorney's fees or penalties that you could recover under CASPA. So you take those steps in order to continue to increase pressure on the owner and get yourself paid. So those are the 3 major topics we were going to cover today. We're coming up on, let's see, about 17 minutes, and we have a little bit of time for questions here. I don't see any in the chat, and so unless there are any questions, I'll turn this back over to Jesse.
Well, first of all, thank you so much, Chad. That was wonderful information that you provided. As for the questions, I don't see any questions either at this time. However, if anybody does think of a question, please feel free to reach out to myself or Chad, and we'll be sure to answer any questions. Can you go to the next slide? Perfect. Please take a moment and review us on Google. We would really appreciate it. And that is all we have for you today. Thank you so much for everyone that attended. We hope to see you at our next webinar. Have a wonderful and sunny day.